When I showed this title to some colleagues, they said I was going to have things thrown at me. However, I decided to leave it like that because it does illustrate, I think, the deeply divided, almost schizophrenic or conflicted attitude that we have with animals in our Western society. The idea that animals are mere automata or robots or some kind of mechanical creatures, although traced back to Descartes, actually has a much older pedigree. Descartes himself, of course, was massively conflicted about animals. On the one hand, he's the poster child for how awful people can be towards animals. How dare you think of animals as like clockwork springs? But on the other hand, he was devoted to his pet dog, Monsieur Grappe, who used to follow him everywhere and used to eat from his table and sit on his lap. And this characterises, I think, a little bit of the cognitive dissonance that exists across Western society. It also has a deeply theological or deeply religious pedigree as well, particularly in the Christian tradition, although we should not romanticise the Buddhist tradition either. It's true that the Buddha did speak out against animal sacrifice at the time that he was teaching, and it's true that subsequent Buddhist inspired rulers like Ashoka in the Mauryan Empire did erect stelae and carvings outlawing cruelty towards animals and indeed mandating vegetarianism in his own kitchen. However, the Buddha was not some kind of proto-eco-warrior, nor was he necessarily overtly concerned with the fate of animals. He regarded them as sentient beings like you and I, similarly trapped in this endless round of cyclic existence, and therefore deserving of compassion and exercise of benevolence and wisdom as the next person. The kinds of environmental problems that we face today, global warming, carbon footprints, deforestation, massive animal exploitation, carbon capture, all of these issues were just not on the radar of the Buddha at the time. There are normative resources in the Buddhist tradition for an animal ethic, and it's a beautiful animal ethic, but I'd like to emphasise that we shouldn't over-romanticise the Buddhist tradition in relation to animals. There are also some quite contradictory things there. We'll leave that alone for the moment. So I've been asked to talk to you this afternoon, or share some thoughts with you this afternoon about animals as beneficiaries of competition and consumer policy. This is very strange. You would not ordinarily think that competition and consumer policy, deeply anthropocentric as it is, could benefit animals in any way. So what am I going to possibly say about this? We know that competition and consumer policy has suddenly assumed a role in advancing animal welfare. We know this because the Australian Competition and Consumer Commission, an organisation that I worked with as a senior lawyer for 12 years, has started to take some action. What are the legal and regulatory implications of this increased role that competition and consumer law might have for animal welfare? This goes to another, I think, important point. We all want to save the world, but we don't want to help mum with the dishes. We all want to save the world, but when we start, we think, oh, it's too hard. I'll just go and watch season 3 of Orange is the New Black or something. When we think about the vast gap between our aspirations and our capacities at the moment, it may seem this task is impossible. For certain enlightened and certain accomplished individuals who have appeared and spoken before us today, who have the resources, the expertise and the ability to do some grand projects, some truly excellent and meaningful initiatives. These are things to which we can aspire, but things to which we should not feel bad about ourselves if we are unable to achieve them on the same scale. Everybody has to start where they are. In 1996, I worked with Mother Teresa the year before she died. It was in London and Tangier. And in Tangier especially, it was so hot, so overwhelming. She was working with unwed mothers at the time, who were, of course, at risk of being stoned to death in that deeply Islamic culture, repressive culture at the time. And I asked her, how can you possibly cope with all of this endless arrival of these poor people? And she said, you just start with what you have, with what you can, with what you do. Just one, that was her favourite phrase. Other than also saying, Alex, you talk too much. She made me say, she said, okay, for the next 2 weeks, before you open your mouth, Alex, you have to ask yourself 3 questions. Is it kind? Is it true? Is it necessary? And I didn't speak much for a month or something. Anyway, the point is that you're all lovely, these young lawyers. You're all here today because you have this passion and interest in advocating for the welfare of animals, just as I have. You have to start with what you have. Now, I'm not a philanthropist. I don't have $1 million. I don't have $1 million. I'm a monk, as you can see. Unusually, my abbot and the Dalai Lama sent me back out to the university to teach rather than off to a monastery. And I think, what on earth can a monk who's supposed to be a renunciate, teaching in a university, teaching of all damn things, competition and consumer law, do for animal welfare? I mean, this is the dark empire, that exploits these animals. And then I began to think, well, lawyers are just starting to assume a really interesting role in animal welfare advocacy. Traditionally, this field has been occupied by philosophers on the one hand. We heard of Peter Singer's seminal contribution back in the 70s and his continuing advocacy. On the other hand, we have the activists who draw our attention to the exploitation suffered by animals. The middle ground has largely been absent. This middle ground is occupied by you and I, the technicians, the advocates who can draw together the passion of the activists and the concern, as well as the intelligence and learning and skill of the philosophers. If we are to make a difference, if we are to change the way society thinks about animals, it starts with what you have, your skills in the courts. You who will be the future judges, you who will be the future legislators, you who will be the future senior counsel. Law can therefore be a very powerful instrument of social justice if it is directed appropriately, and if it is motivated and directed by wisdom and compassion, supposedly my 2 favourite words, then for animals, there are no better beneficiaries. You all have, no matter what area of law you are interested in, the capacity to advocate for animal welfare. You start where you are with what gifts you have. By this time, of course, I had finished practicing law with the ACCC. And of course, moving to the National University as a professor, of course I get the usual hackneyed phrase, well, those who can do, those that can't teach. And of course I say, well, yeah, what about those who can, those who did, those who don't want to do it anymore, and those who want to teach and do something else? This is what we do. We do something else. We adapt, we change, and we look for other ways of advocating. It took me 2 years to convince the sometimes conservative faculty at the ANU College of Law to let me teach an undergraduate animal law subject. And in fact, to my shame, the only way I was able to ram it through the education committee was by stacking it. I put it on for vote at the time of the student representative changeover, so there were 2 lots of students, and they carried the vote. A bit sneaky. I had to think carefully about the ethics of that. Anyway. So here's someone who does not have a lot of money, does not have a lot of voice in Parliament, does not have the ability to go in with guns blazing, but nevertheless I can try to make a difference by advocating and teaching future generations. This is where I can make a difference. Likewise, as you go through your professional lives, you will find where you can make a difference. At the bottom of it all, at the heart of it all, of course, is information and knowledge. You have to think carefully about new ways of using old legal frameworks to create change. Voiceless, for example, as you all know, have a wonderful lecture series every year. And over the past few years, the ANU has been proud to be associated with this lecture series. We've had visits most recently from Joyce Tischler, who's been using very imaginative litigation in the United States to advocate for animal welfare. And just this year, of course, We had Stephen Wise from the Non-Human Rights Project with his imaginative use of habeas corpus. If habeas corpus, this ancient common law writ, can possibly be used to such dramatic effect, why not competition and consumer law? This is what I thought might show some interesting possibilities. I didn't know what those possibilities were, but I thought, why not have a bit of a look? What am I really going to talk to you about? Well, there's a few things I wanted to talk to you about, but which I'm going to sort of skip over a lot because I wanted to moderate this talk by reference to some of the comments that were made earlier. A few things. Firstly, I was staggered to get an update on the figures that we encounter. The March 2015 figures, for example, total red meat production, 940,000 tonnes. Chicken meat production, 279,000 tonnes. 159 million animals slaughtered. Of those, 148 million chickens. Huge amount. Look at the Egg Corporation figures in its most recent annual report. 183.4 million dozen eggs, with cage eggs representing 53% of that figure. We have this huge demand for eggs. And meat. And when the meat industry, Meat and Livestock Australia and the other participants in the meat industry introduce these sorts of campaigns to have lamb, to throw a shrimp on the barbie, going back a few decades, and get famous figures to advocate a link between evolutionary development and eating meat, it's quite difficult to refute. It's going to get worse before it gets better. By 2050, the UN Population Division thinks we're going to have between 8 and 11 billion people on the planet. Much of this demand is going to come from China. Much of this demand is going to come also from India, these Asian countries. In fact, the China Free Trade Agreement, which we signed this year, provides for the elimination of the current tariffs over 4 years, and China's demand for beef is expected to increase hugely. You can see some figures, 2013 and 2014, we exported $790 million worth of boxed meat, an increase of 3,000%. That just gives you some indication. And now we're about to start exporting live animals once the facilities are up and running. We're going to need to increase food production generally to meet these population demands by 70%. But to do so, we will have to face declining agricultural resources, worldwide decline in land, worldwide decline in arable opportunities, dwindling fossil fuel supplies, and the general movement of people off the land into urban areas. The National Farmers Federation doesn't seem to be concerned. In its 2012 Farm Facts report, it's suggesting, and you can almost get a sense that it's rubbing its hands with glee, saying we're going to really cash in on this demand, particularly from Asia. The primary industry sector intends to profit from this extra demand through concentrated animal feedlot operations, of course. It's not going to invest in ways of producing alternative forms of agriculture. It's going to advocate for plant-based diets or even artificially grown meat products that now are starting to be developed. They're going to just keep on packing more and more animals into more and more efficient feedlot operations. So we've all seen these sorts of images before. I'll skip through them quickly. From a competition and consumer law perspective, from the competition side of things, if you like, I'll just swap hats slightly for a moment. From the supply side, at least in Australia, most of the meat that's produced and most of the poultry that's produced comes from a few dominant players in the industry. Virtual duopoly and a virtual oligopoly in both industries. Corporations that have the vested interest in economic efficiency. When the Competition and Consumer Act has as its principal aim the welfare of Australians through the provision of fair trade and consumer protection, they're not talking about the welfare of animals, they're talking about the welfare of humans, deeply anthropocentric. Corporations, of course, follow this mantra through this neoclassical lens of economics, neoclassical economics. They're rational profit maximisers, and so it just makes complete sense to them to attempt to squeeze more efficiency by subordinating the welfare of animals to the profit motive. Of course, it's made completely possible by legal systems around the world, Australia just one example, where non-sentient legal fictions like corporations are invested with legal personality and able to own sentient warm-blooded creatures which are regarded legally as property, completely inverting the reality. In the process, of course, these corporations, these sentient legal fictions, which have the capacity to own sentient creatures like chickens and cattle, but who are legally characterised as toasters or lamps, for example, the primary responsibility, of course, of the corporations is to the shareholders, not to animal welfare, which is why, in a contest, in the inevitable conflict and contest between animal welfare and productive efficiency, animal welfare is continually subordinated to the profit motive. Animals are therefore completely regarded as an input, an economic input into a larger process of production. And while some animals are offered some measure of protection against unnecessary suffering, of course the majority are not. We can legally treat, this quote that I came across was fascinating, human beings do not treat animals harshly because they're classified as property. Animals are classified as property so that human beings can legally treat them harshly. Playing with legal words, but nevertheless accurately summarises this disjunction between the corporate non-sentience and the animal's sentience, one owning the other. And of course, it's no wonder that this dissonance has resulted in these completely contradictory legal and regulatory aims. So on the one hand, governments throughout Australia attempt to protect some classes of animals from cruelty while simultaneously encouraging primary industry to exploit whole herds of animals for the economic profit motive to satisfy our human food preferences. Not needs, wants, basically. So there you are, Descartes. All of these, of course, are legalised through these different model codes of practice, which I won't go through. We had this labelling logic report, of course, which attempted to bring some certainty into the way animal products are labelled. And this is where I think, in this context of what information is provided to consumers, so from the demand side now, that competition in consumer law might well be an avenue for benefiting animal welfare. So the government decided in its report that consumer values issues, these are the things that you and I are concerned about as consumers. Are these eggs free range? What animal husbandry practices have these corporations engaged in raising this animal to be slaughtered? All of these welfare and values issues are to be treated and regulated through the mechanisms in the Competition and Consumer Act, but particularly the Australian Consumer Law. So the government is not going to start introducing rafts of animal welfare legislation to ensure that producers of animal products engage in better animal welfare practices, husbandry practices. Instead, they're going to say, well, if you make misleading and deceptive remarks or comments about the food products that you put out into the market, then you might be liable under the Act. So they're simply going to use market forces in the form of consumer demand to exert upstream market pressure on these primary industry producers to implement food animal welfare initiatives. Now, it sounds great in theory. Does it work in practice? Well, to some extent it does. We're regularly bombarded in the media with these sorts of things. This is the only time a Steagall's chicken is kept in a confined space. No eggs, no cages, just big barns. But of course the reality is, at Animals Australia, undercover investigation films, it's nothing even remotely approaching the truth. We have very little consistency in labelling laws, and so producers can put pretty much what they like on their products. And of course, the Australian Egg Corporation recently took advantage of that lacuna, that gap in the regulations, to attempt to permit a label of free range applying to this stocking density of up to 20,000 chickens per hectare. In other words, a 91.6% reduction in the available space of chickens now, while still being legally able to advertise that these eggs produced in that circumstance are free range. Ridiculous. Not surprisingly, it was rejected. Using competition and consumer law as a mechanism for improving animal welfare has had some success. Here are a list of recent decisions that we know about where the ACCC has taken action against producers of eggs and poultry products, where they have misled consumers into thinking that the eggs are free range or the animals are free to roam, making value statements about animal welfare conditions and those statements being proven to be false. This is, however, a double-edged sword. Why? So here's the section of the Australian Consumer Law, section 18. Person must not in trade or commerce engage in conduct that's misleading or deceptive or likely to mislead or deceive. A very wide provision. You as lawyers know that this litigation under section 18 is encroaching on tort and contract. You no longer have to establish privity of contract. You no longer have to establish a duty of care. In fact, the standard of evaluation under section 18 is lower than the reasonable person test. So it's a very wide sort of provision. The big sticking point, or the other side of the sword, double-edged sword, the other side of the sword is that because section 18 of the Australian Consumer Law operates in circumstances where a corporation or a person is engaged in trade or commerce, on the one hand, you can see how companies that produce eggs, companies that produce poultry, companies that produce some forms of meat might be regarded as, or can easily be regarded as being in trade or commerce, and thereby justiciable under the Act if their conduct is misleading or deceptive. But now, what about advocates for animals? What about Animals Australia? What about Voiceless? What about Bleats? What about animal welfare interest groups who set up a blog or a Facebook site? What about statements that are made by any of those animal welfare organisations that are directly intended to influence negatively the bottom line, the trading position of their target company? Is that conduct in trade or commerce? The point that I'm trying to communicate to you here is that by all means, the law says that the consumer law can be used to hold animal food producers to account for the representations that they make relating to animal welfare conditions. The law can be used to exert upstream market pressure on these organisations to implement better animal husbandry practices. But can those same laws be used to shut down debate, criticism, or advocacy on the part of animals where those advocacy or where those statements are being made and targeting a producer? Ordinarily, this would not have been a problem, except that we had a decision of the High Court in 2006, Horton and Arms. Horton and Arms statements made by a person not himself or herself engaged in trade or commerce may answer the statutory expression if, for example, they are designed to encourage others to invest or to continue investments in a particular trading entity. When you think about that, when you think through the implications of what the High Court is saying there, what happens if, for example, Animals Australia has a television campaign highlighting the adverse animal welfare externalities associated with live exports, prominently displays the corporate logo of a certain live exporter, there's a backlash against that live exporter, their share price drops. Is Animals Australia liable under Section 18 for engaging in misleading or deceptive conduct? I leave aside for the moment the issue of whether there is actual misleading or deceptive conduct, looking at this threshold issue of in trade or commerce. We all know as lawyers that even if at trial Animals Australia might be found not to have engaged in misleading or deceptive conduct, the very fact of having instituted proceedings, the very fact of, for example, the export company seeking an interim injunction, may well have the same effect as final relief, shutting down any further investigation by Animals Australia. This is something that is quite important. The subsequent cases and prior cases are divided on exactly this issue. So we have these two cases that are classic here. Both of them involved attempts to influence the trade of another party, and yet they were completely contradictory decisions. One in trade or commerce, the other not. So, for example, the Horton and Arms decision potentially, in my view, suggests there's this expansive interpretation of this word in trade or commerce under the consumer law that potentially exposes animal welfare advocates, your clients, for example, if you act for them, to at least nuisance litigation or harassment litigation, I think, by agricultural companies under the Act. So there are a number of possibilities. Where you have a corporation or NGO seeking to influence public opinion about certain ethical issues, where the NGO does not have a commercial interest in the public adopting a particular conclusion, you have this decision before Horton and Arms which says not in trade or commerce. Where, for example, you have a corporation or NGO seeking to influence public opinion, where you do hope to achieve some financial or commercial gain, then it is in trade and commerce and you can be potentially liable. Two very recent decisions. Full federal court in Seafoley and Madden. Miss Madden operated a Facebook page devoted to her swimsuit retail business. She accused Seafoley of copying her swimsuit designs. Seafoley had not in fact copied her swimsuit designs. Those swimsuit designs had been, Seafoley's swimsuit designs had been put into trade, in fact, up to 8 months to 10 months beforehand. Miss Madden nevertheless made very passive-aggressive comments on her Facebook site, disparaging Seafoley. Now, corporations can't sue for defamation, but they can sue you for misleading or deceptive conduct. If, as I'm thinking, Horton and Arms in the High Court has expanded this notion of in trade or commerce, could an agricultural company who is just royally cheesed off by the actions of your client in investigating and making claims about its animal husbandry practices, no longer being able to sue for defamation, now able to suddenly institute proceedings against your client alleging misleading or deceptive conduct? Seafoley did exactly that and won. The full court said that yes, Miss Madden's comments were in trade or commerce because, under the Horton and Arms formulation, she was attempting to influence the trade and profit of Seafoley Pty Ltd. Most recently, you've got these two new cases, Fletcher and Nextra and ACCC and Homeopathy Plus. Cases that involve public debate. Now, it's a fundamental tenet of Australian law that organisations, people, community groups have the right to engage in public debate about particular issues. It's part of the healthy democratic process. What we're seeing here potentially, however, is the danger of a potential chilling effect on this public debate, where there's some allegation that this public debate is going to have an effect on the bottom line. Now, this is more than just academic speculation. Everything now is commodified. Everything in our Western society is all about the bottom line. We live in a corporatised, neoclassical market, liberalised market. Anyone who has an interest, financial or otherwise, in a particular issue can in some way now claim that, I'm hoping to get sponsors for this public event. You criticising me in the course of public debate is impinging on my bottom line. Therefore, you're engaged in trade and commerce, and therefore I'm going to sue you under the Competition and Consumer Act. The ACCC took proceedings against this company, Homeopathy Plus Australia Pty Limited. Homeopathy Plus had entered the often fraught debate about the wellness industry, these wellness warriors who say all you have to do is go to a few Buddhist retreats and you'll cure yourself of baldness or something. Homeopathy Plus, in this case, it was a debate about the virtues of tuberculosis vaccines, saying that you don't have to get vaccines. Vaccines are the devil's work, and all you have to do is have a few of these herbs, and by the way, you can buy them here. Misleading or deceptive conduct. Yes, it was, according to the ACCC. Homeopathy Plus argued, no, we're just engaging in public debate. The public needs to know both sides of the story. Not so, according to the ACCC. Not so, according to the courts. It goes further than just mere public debate. You're actually influencing trade and commerce. Fletcher and Nextra involved a newsagent franchisor going onto a blog site to make certain comments about a rival franchisor. Rival franchisor can no longer sue for defamation, so sues under Section 18 of the Competition and Consumer Act, saying you're in trade and commerce, you've made these comments in trade and commerce, you're affecting my bottom line, you've broken the law. And the full court agreed. As a result of the arms decision, would, for example, Orion Pet Products at RSPCA, decided 4 years before Horton and Arms, be decided the same way today? RSPCA Victoria made these comments about the alleged cruelty of electronic dog collars. Clearly the comments were designed to stop people buying these dog collars from Orion Pet Products. Could Orion Pet Products now claim that the RSPCA had engaged in misleading or deceptive conduct? So while effective and thoughtful use of the Australian consumer law can help and generate animal welfare reforms, it also has the possibility of backfiring. You need to be aware of that. The ACCC is the principal regulator, of course, of the Australian consumer law, and it has, at the moment, at least anyway, a fairly specific consumer protection strategy which can have tangential effects for animal welfare advocates. The larger imperative, of course, is that this is just a simple band-aid on a larger problem. As has been mentioned by speakers this morning, simply using our legal skills, simply using the law to address larger animal welfare issues does not absolve society more generally of seeking a more permanent ethical and fundamental philosophical shift in the approach to animals. But until we get to that stage, and until we can hold some corporations accountable, the use of competition in consumer policy, although at least counterintuitive in its presentation, may well be one avenue for you young lawyers to think about.